All right, today we're going to dive into a landmark case, one that anyone in the legal field absolutely needs to know: Katz versus the United States. This is the story of a gambler, a regular old public phone booth, and a Supreme Court decision that completely changed the game for Fourth Amendment protection, especially for the world of tech we live in today. It's a pretty wild question, right? How on earth did a simple glass box on a street corner become the very center of a legal revolution? Well, to get it, we need to unpack what the law looked like before this case came along. Let's dig in. So here's our roadmap. We're going to start with the old way of thinking, what's called the Trespass Doctrine. Then we'll look at the shift through a really interesting lens I'm calling a grammar of privacy. After that, we'll get into the nitty-gritty of Charles Katz's case, see how the Supreme Court turned everything on its head, and finally, talk about the massive impact this decision still has today. Okay, so to really appreciate how groundbreaking Katz was, we have to understand the world it replaced. And that world was all about something called the Trespass Doctrine. Now, at the very heart of this is, of course, the Fourth Amendment. The debate for years wasn't about whether it existed, but what it actually covered. What exactly counts as a search in the first place? That was the million-dollar question. For a long, long time, courts had a really simple answer. They looked at the Fourth Amendment through the lens of property rights. Basically, for the government to violate your rights, they had to physically trespass onto your stuff: your house, your office, your property. If there was no physical intrusion, well, then there was no search. Simple as that. And to really wrap our heads around this huge shift, it's actually helpful to think about it in terms of grammar, specifically the phrase "used to." It's a simple way to see what the law did and, more importantly, what it didn't do. So let's break it down. The law used to link your rights directly to your property. It was all about physical space. Because of that, the law didn't use to protect things you couldn't physically touch, like a conversation. Your words, once they were out there in a public space, they had zero constitutional protection, as long as the government didn't physically trespass to listen in. This is the crucial gap in the law that the Charles Katz case is about to blow wide open. And that brings us right to our guy, Charles Katz. His case, and the technology involved, would force the Supreme Court to take a hard look at its old, outdated rules. So the facts of the case are pretty straightforward. Charles Katz was using a public phone booth to place illegal bets across state lines. The FBI was onto him, so they put a listening device on the outside of the booth. Notice that, the outside. They never went in. They didn't trespass. They just recorded his calls, and boom, Katz was convicted based on that evidence. Now, this method the FBI used, this is a classic case of wiretapping. And it was the perfect test case, really. It was surveillance without any physical intrusion, and the old Trespass Doctrine just had no idea what to do with it. You have to admit, the government's argument made perfect sense under the old rules. They basically said, hey, we never set foot inside the phone booth, no trespass, no search, no problem. They were playing by the rules of the game as it used to be played. But, and this is the big turning point, the Supreme Court saw that technology was creating a massive blind spot in the Constitution. They knew it was time to change the rules of the game. And it all boils down to this single, iconic line from the majority opinion: the Fourth Amendment protects people, not places. Wow. I mean, that one sentence was a legal earthquake. It shifted the entire focus away from property lines and squarely onto personal privacy. So to make this new idea work, Justice Harlan, in his concurring opinion, gave us a brilliant two-part test that legal experts still rely on every single day. First, you ask, did the person have a subjective expectation of privacy? In other words, did they act like they wanted privacy? And second, is that expectation objectively reasonable? Is it the kind of privacy that we as a society think is fair? So when the court applied this test to Charles Katz, it was a no-brainer. When he went into that phone booth and shut the door, what was he doing? He was trying to keep out the uninvited ear. He absolutely had a subjective expectation of privacy. And the court said, yeah, that's reasonable. Society agrees that when you shut the door to a phone booth, your calls should be private. Look, the impact here was just monumental. It wasn't just about this one case. Katz created a whole new playbook for privacy that reached far, far beyond that phone booth on the corner. You can see the domino effect right here. The Katz test became the foundation for all sorts of new surveillance laws in the 70s and 80s. And as technology just exploded, from emails to cell phones to cloud data, this reasonable expectation of privacy test became the main tool courts use to figure it all out. So if you remember just one thing from this, make it this. Katz is the reason our constitutional protections evolved with technology. It's the case that ensured our private conversations, whether we're speaking them or typing them, are protected by the Fourth Amendment. It took the law from what it used to be to what it had to become. And that leaves us with the big, complicated question for our own lives, right? The whole Katz test hinges on what we as a society think is reasonable. So in our world of public Wi-Fi, Instagram stories, and data clouds, what's reasonable now? The legacy of that phone booth is that we have to keep asking ourselves that very question again and again.